Melissa Murray is a professor at NYU Law School. George Conway is a conservative attorney and the president of the Society for the Rule of Law. They join me now. Thanks to both of you. Melissa, I want to start with you. You were, I think, on air when this ruling came out, if I recall correctly. What was your reaction to that and when you heard the news? And what do you think this means in general for the civil rights of Americans in this country?
So it wasn't an unexpected ruling. It was very clear from oral arguments back in May that there was certainly some antipathy, if not downright hostility, toward the possibility of nationwide injunctions, that there was some significant cadre of the court that were ready to rein this in. And so I want to be clear about what this decision does and what it doesn't do. It does not take up the substantive question of whether Section 1 of the 14th Amendment confers birthright citizenship. So that was actually never on the table. The Trump administration chose not to present that question to the court. And that by itself is significant because it understood this case to be purely a vehicle for narrowing the injunctive power of lower federal courts to stop this administration when it does lawless and unconstitutional actions. And the court essentially delivered that today. They narrowed the available remedies that district courts can use when they are faced with the lawless actions of this court. It said here that in this particular case and in others like it, if there is a litigant and that litigant's relief can be afforded simply by giving that one litigant relief, you don't necessarily need to have a broader nationwide solution. So it didn't foreclose entirely the possibility of nationwide injunctions, but it made it much narrower and much harder for district courts to justify issuing a nationwide injunction. And that's really critical because right now, when we have Congress sitting on the couch somewhere in Washington, D.C., there are precious few checks on this administration, and we have been relying on the lower federal courts using their injunctive powers to stop this administration when it does something that is utterly lawless and utterly unconstitutional, which has happened with increasing frequency.
How do you think other judges on lower courts, which was once the position of these Supreme Court justices, feel about their powers being clipped here?
Well, to be clear, most of the justices on this court were never district court judges. Only two, Justice Sotomayor and Justice Jackson, were ever on the district court. The others were federal appellate judges. And in this particular opinion, there was so much antipathy for the work of district court judges. District court judges, I've clerked for one. They work and labor really hard. They try to do the right thing, and they recognize that they are the front lines. They are closest to the litigants. They often see the litigants in a way that appellate judges like the Supreme Court do not. And the antipathy for district court judges was absolutely striking in this opinion. Justice Kavanaugh, in his concurrence, essentially said, the buck stops with us. We are the ones that get to make these decisions. If there is an imperial judiciary, and that was a point of contention between Justices Barrett and Jackson, at least for Justice Kavanaugh, the most imperial judiciary is these 9 members of the Supreme Court.
George, a lot of commentators today, and in fact, Justice Ketanji Brown Jackson, in her dissent, are saying that this leaves everyday people to effectively fend for themselves when it comes to government infringements of their rights. How do you see it?
I disagree. I don't think this decision is a big decision, a big significant decision at all for most of the people watching out there. I think it's going to be an interesting decision for students of the federal rules of civil procedure and class action procedure, but I don't think it's going to have much of an impact. And I think the decision is actually correct, much as I agree with everyone that what the administration here is trying to do to the 14th Amendment, Section 1, is pretty much it is a depraved and insane interpretation of the 14th Amendment that only the likes of President Stephen Miller could come up with. I mean, essentially, what the court this is the equivalent of going to the DMV or going to the passport office and showing up at the window with your form and being told, no, sorry, you have to fill out a different form. And the form's over there on the table and there are pens on the table and you have to just come back. And what happened here is Justice Barrett is absolutely right. This is not a traditional form of injunction. The way you get an injunction of the sorts that have been issued here is through a class action. And I know that sounds burdensome. It sounds big. And I know I practice class action law as a defense lawyer, and it's very, very difficult to get, to deal with class certification issues in a big case involving antitrust and securities and things where you have to hire experts and so on. This is the most pure form of class action, where basically it's up or down on the interpretation of a few words in the Constitution, which I think can't be interpreted any other way than the way that these judges and the plaintiffs have found it. And so what's going to happen here, the reason why we saw multiple lawsuits brought this afternoon is 10 weeks ago when the Supreme Court decided to hear argument on this stay application, everybody realized which way it was going to go. So they just wrote new pleadings that said, we're going to ask for a class action. And what's going to happen next is the courts are going to say, yeah, OK, we're going to certify class actions. And frankly, there is no basis to oppose the certification of a class action here because it is so simple. It's one issue of law. It's straight up or down. And we're going to have four law, maybe not perfectly nationwide injunctions, but four very broad injunctions, maybe even nationwide, that are just simply going to be issued in class actions, which eliminates the problem. And so
George,
I think we're just going to end up in a very short
Melissa
order.
has been vigorously shaking her head for a while.
Because, George, you are wrong.
Okay.
You are wrong, and you know you are wrong.
Okay.
First of all, this case, Trump versus Casa, involves not just individual litigants, but also states as litigants. And you know, as a lawyer, that the federal rules of civil procedure do not permit states and organizations like Casa to present themselves as candidates for class actions. Federal Rule of Civil Procedure number 23 only applies to persons. So the idea that anyone could go forward as a class action is absolutely ludicrous, and you know that. This was the only remedy available to lower federal judges to rein in this particular administration. Now we are asking individual litigants to either go to every district court throughout the country to individually file suit or to alternatively launch a broad class action for which many of them don't have the resources. And right now, at a time when this administration has forced law firms to capitulate, further narrowing the availability of legal resources, the fact of a class action is going to be virtually impossible, and you know that. This is a devastating decision for the rule of law. It is a devastating decision for the rule of law. It is a devastating decision for democracy, and it is part and parcel of this court that has, for the last 2 years, facilitated this president in what has been an utterly lawless march through constitutional law.
George,
I admire you and I love you, and I agree with a lot of what you say, but you're wrong. Federal Rule of Civil Procedure 23B2 basically says this is exactly the kind of case where a class action should be certified.
Not
and yes,
with the state,
states
George.
Can't ask,
not with organizations like Casa, George.
But there are individual. Excuse me. Individuals can bring large class actions here, and the states have every right to seek a relief that affects them, which means people who are moving into the state, people are in the state. So we're going to get full relief in very, very short order. And I don't think this case is going to make a big difference in any of these cases where, the government is violating. Yes, it's an up or down issue as to whether or not the government is violating the law. And, everybody's similarly affected. There is a mechanism for doing this. It's Rule 23B2, and that's where we're going to end up. And I think
before
we're going to end up
we
in the same place. We'll come back in a matter of weeks, and we'll see who's right.
Okay, before we get too in the weeds on some of these particular provisions, I do want to ask what this means in practice for people who are affected by this. So, Melissa, my question to you is effectively, what happens to babies born in states where the birthright citizenship executive order is not being blocked? There are some states where babies are born citizens, and there are some states where babies are not born citizens. Maybe they're stateless. What happens if you're born in if you're a parent and you have a kid who's born in Texas, let's say?
So there's a 30-day kind of delay before this opinion becomes operative. That gives the administration an opportunity to draft some guidance for how this will all play out in the various jurisdictions, both where it is blocked and where it is not. But we are looking toward what will essentially be a kind of patchwork in the United States, and that shouldn't be unfamiliar. With this administration, we've seen patchworks before. Consider the Dobbs decision from just a few years ago, where we went from having a fundamental right to choose an abortion to having a patchwork where we have some states where it's permitted and other states where it isn't. So it is going to be chaotic. It is going to be uncertain and unsettled. And that kind of chaos is, I think, by design, to make it less likely for individuals to come forward to claim their rights, to make it less likely for individuals to come to the United States, and to make it more likely that people will be unwilling to live with this kind of uncertainty and will self-deport or otherwise take themselves out of this situation.
The babies are going to Self-deport.
Well, I guess according to George, the babies are going to go get lawyers and file class actions.
George, very quickly, last word to you before we wrap up.
Yeah, I mean, again, I think we're going to end up with coverage nationwide very soon, because there are going to be multiple lawsuits, multiple class actions, and there are going to be broad injunctions issued against this unlawful and outrageous interpretation of the 14th Amendment.
Melissa Murray and George Conway, thank you both for your perspectives.